three co-equal branches that balance each other. So what's at stake? The US Supreme Court will be deciding whether state legislatures should be given the absolute and supreme power to create voting laws and redistricting maps for congressional elections without any checks from state constitutions which define their power or judges who interpret those constitutions. After the 2019 Rucho decision, Common Cause and advocates across the country took the court's advice to heart, and we relied on state courts and state constitutions to rein in partisan gerrymandering. States like Virginia adopted redistricting commission through a final vote of the people. And in other states, advocates brought litigations in state courts to establish similar rules to rein in what even the Supreme Court recognized was a scourge on our democracy. It is all at risk with Moore v. Harper. Once again, it could mean that partisan politicians elected through gerrymandered and unfair districts, unaccountable to the people, would be able to narrow the ways already used to disenfranchise Black, Brown, and new voters, and to create a situation where elections are rigged from the start and the choices are already made before the beginning of the decade. This decision will not only impact North Carolina, where this case originated when Common Cause North Carolina and Southern Coalition for Social Justice and others challenged the illegal and unjust redistricting maps by the state legislature. Moore v. Harper could impact every voter in the United States. How we cast our ballots, what accessible voting options we have, whether we are going to have a secret ballot or not, whether state courts have a say in interpreting state constitutional provisions on the elections, and of course, whether state legislatures can draw congressional maps that entrench the power of incumbents or one party rather than representing the will of the people. At the worst case scenario, we could see 200 years of legal precedent wiped out, an anti-originalist interpretation of the Constitution made into law, and federal elections throughout our country upended. Today, we'll be hearing from Allison Riggs, co-executive director for Southern Coalition for Social Justice and legal counsel for Common Cause in Moore v. Harper. She argued the Rucho v. Common Cause case with us in 2019, and she helped secure the decision from the Supreme Court that the partisan gerrymandering was a scourge that we needed to address, and that was best addressed by state constitutions, state action, state judicial review, and other innovations at the state level. She will be talking about the joint brief that we at Common Cause and SCSJ and other respondents put together, our legal strategy, and she'll also touch upon some of the 47 amici briefs filed that present a wide range of bipartisan leaders and legal scholars in support of our position over the last week. The full scope of disruption that this case could inject in our elections process is starting to come into focus. An amicus brief filed yesterday by Brennan Center tallied the extent of uncertainty that would come with more than 170 state constitutional provisions, more than 650 state laws, hundreds of state court decisions, and thousands of rules and regulations that could be called into question if the Supreme Court backs the most extreme version of the independent state legislature theory, or as we're calling it, the lawless legislature theory. Finally, you'll hear from Judge J. Michael Luttig, a formidable addition to our legal team. Judge Luttig spent the last 15 years on the federal bench after he was appointed to the U.S. Court of Appeals for the Fourth Circuit by President George Bush in 1991. He wrote about how the so-called independent state legislature theory had no grounding in our Constitution and called it the most important case for American democracy since our nation's founding. Judge Luttig was at the center of the discussion when this crazy theory was being bandied about in 2020. And I'm sure that he will be sharing more about that insight and why it is so dangerous for multiple reasons for the court to go in this direction. Whether we're talking about red or blue states, the dangers of a runaway, unresponsive, unaccountable legislature is always the same. Checks and balances are fundamental to our government. It assumes that each part of the government plays an important role in making sure that we do not have runaway power for any one branch of government. And that checks and balance function of our state courts could be wiped out in one decision. So what's the solution? The first and most obvious one is a win before the Supreme Court, emphasizing that 200 years of legal precedent and an originalist inspection of our Constitution must lead us to the conclusion that our system of checks and balances has to be preserved. Before I invite our speakers up, I encourage reporters who may have questions while our speakers are presenting to use the Q&A button to type your questions. I will be monitoring them, and I'll make sure that we are asking them as much as possible in order. After all three speakers are done, we will start the questions with that Q&A function. We are recording this entire session and streaming it online, and we'll be sharing that recording after the briefing. And with that, I am very pleased to introduce Allison Riggs, our legal counsel from Southern Coalition for Social Justice, to talk more about our legal strategy in this case. Allison?
Thank you, Kathy. Good afternoon or good morning, wherever you are today. Thank you for joining us to talk about this critical case. Back in 2021, 3 different groups of plaintiffs, Common Cause being one of them, filed lawsuits challenging a rushed, unfair, and ultimately anti-democratic redistricting process that happened here in North Carolina. Those 3 plaintiff groups have worked together throughout the course of this litigation, securing a win in front of the North Carolina Supreme Court and working together on this next level, this question in front of the U.S. Supreme Court currently, whether judicial review is a mechanism for accountability for state legislatures. Last week, we were so pleased to submit a joint brief amongst all 3 parties outlining our arguments. And of course, I'd be remiss to say that we were very lucky to have Judge Ludig join us in thinking through these issues as the scholar that he is and arriving at what we're very proud of as an amazing brief. And I'll briefly go through that just to highlight some of the important issues that we're facing, that we're raising in front of the court. First and foremost, the text, the structure, and the history of the United States Constitution, a document which we all hold dear, support our position that judicial review of state legislative actions is a norm and is understood and woven through every part of the United States Constitution. The framers knew when they were drafting the elections clause that state legislatures only exist because state constitutions created them, and that the power to create state constitutions lies with the people. And in forming this country and a government that would resist authoritarianism, create healthy checks and balances, and ultimately be politically responsive to the people itself, judicial review, the ability of courts to check legislative bodies for compliance with constitutions, is a very important part of that. So the vast majority of our brief discuss that. The history is overwhelmingly on our side, and we believe that this will be a compelling argument. We also talk about the 100 years of cases that support this position. Precedent and respect for precedent, stare decisis, isn't necessarily the be-all, end-all, but this is it's a stabilizing consideration And it would be indeed quite disruptive to overturn 100 years of case law that recognizes and endorses the ability of courts to play a role in checking the constitutionality of laws passed by state legislatures. And finally, like many of the amicus briefs submitted just yesterday, we raised the considerations of what this will mean if this theory, this dangerous theory, is embraced. And of course, we hold in the highest regard the election administrators that make our democracy work during every election. And we want them to be able to do their jobs in safety with support, and complicating the rules for conducting federal elections raises serious concerns for the impact on those very valued election officials. Now, I'd like to take a moment to talk about the 47 amicus briefs filed yesterday in support of Common Cause's position. And if there is one takeaway that you leave either this briefing or from a visit to the US Supreme Court website, I want it to be this. This is not a partisan issue. And I'll repeat, this is not a partisan issue. I was so filled with awe and gratitude yesterday as I looked through the enormous list of thought leaders, former elected officials, legal scholars, the bipartisan list of these amazing, brave individuals whose commitment and character and dedication to preserving our democracy was what motivated them and won the day. And all of them, to a T, said that this independent state legislature theory is not what the Constitution mandates. It is not good for our democracy. And it's just not something that this court, it's a dangerous road should this court go down it. I just want to highlight some of the unusual allies, the incredible thought leaders who weighed in yesterday or in the last few days. Judge Thomas Griffith, who used to be on the DC Court of Appeals. I had the opportunity to appear before him. What an amazing leader and contributor to our country. He weighed in favor of Common Cause's position and in opposition to the independent state legislature's theory. Ben Ginsburg, who's a prominent Republican election lawyer who has been involved in so many cases, including Bush v. Gore, saying this is not, this ISLT is not a thing. Federalist Society co-founders Professor Stephen Calabresi and Peter Keisler. These are not, this is not a partisan issue. We are coming together as a country and based on a commitment to democracy. There was a brief filed yesterday jointly by the American Civil Liberties Union and also the Niskansen Center, a center-right think tank, and the Rutherford Institute, a Christian conservative public interest law firm. The range of interest represented here reflect the range of interests and people in this country. And I hope that you take away from this briefing and from what you can read on the United States Supreme Court website that this issue is now one that is bipartisan and one that folks from across our country, across the political spectrum, are coming together to take a stand on. And with that, thank you for your time, and I'll pass it on to Kathy and Judge Ludick.
Thank you so much, Allison. We are happy now to introduce and honored to have as part of our team, Judge J. Michael Ludick. He is a longtime legal scholar and judge, and now has weighed in using his prowess and familiarity with our Constitution, and frankly has brought, I think, a level-headedness to the conversation and deliberation within our legal team to make sure that we are putting our best foot forward as we move towards that December 7th oral argument date. Judge Luttig.
Thank you, Kathy, and thank you, Allison, and thank you, Common Cause. But a special thank you to all of you who have taken the time to join us here today. This is perhaps one of the most complicated cases ever to come before the court, which is to say that very few lawyers even understand the issues at this point, let alone non-lawyers. In fact, there would be at this point very few constitutional lawyers who have a full understanding of the issues that are presented in Moore versus Harper. You know, as Kathy said, this is the single most important case on American democracy and for American democracy in the nation's history. That is, since the founding almost 250 years ago. So let me explain why I say that. It's very simple if I can succeed in simply explaining it. Our American democracy is the process by which we, the people, choose our elected representatives who will represent us and our interests and our views in the federal government, and specifically in the Congress of the United States and in the executive or presidency of the United States. This is the beginning understanding of why this case is the most important case for American democracy since the founding. For this reason, at issue, as Kathy and Allison said, is the so-called independent state legislature theory of constitutional interpretation of both the electors clause and the elections clause of the Constitution. Both. At issue in the 2020 presidential election was the application of the independent state legislature theory to the electors clause of the Constitution. At issue in Moore versus Harper is the application of that theory to the elections clause of the Constitution. But the decision that the court makes in Moore versus Harper will almost certainly have a one-to-one correspondence and relationship to the application of the theory to the electors clause. So the electors clause and the independent state legislature theory, as it would relate to that clause, was actually the centerpiece of the effort to overturn the 2020 election. The former president and his allies began arguing for this independent state legislature theory in the federal courts long before the election itself, and they continued to argue for it in the Supreme Court as late as early December of 2020. At that point, the Supreme Court refused to decide the issue. It declined to grant cert and decide the question. We don't know why it didn't, but I think for our conversation today, we can assume that the court didn't want to insert itself into that presidential election in the way that it had done in Bush versus Gore. Because when the court decides a constitutional issue in the context of a presidential election, there's no question that that it will often decide the presidency by virtue of its decision, and the court is understandably want not to do that unless absolutely essential. But in any event, in the course of declining to decide the case, three of the justices, made comments in separate written opinions, suggesting that they were interested in this theory, and together with those three, together with Justice Thomas, who had been in the concurrence in Bush versus Gore, that led court watchers to reasonably believe that there were at least four justices who were interested in the ISL theory. And then in December 2020, as you'll recall, Justice Amy Coney Barrett had just been confirmed and had joined the court. She did not participate in that case, is my understanding. But again, court observers believe that she too would be interested in the theory, leaving those of us who watched the court closely to believe that there were probably as many as five justices who were interested in the theory. We all knew that the court would take the case at its earliest opportunity, and I think all of us understood that the court would likely take the case in Moore versus Harper, even though Moore versus Harper, as I suggested, presents the case in the context of the elections clause, not the electors clause. So just one footnote to what I've said thus far. The genesis of ISL is literally in the separate concurrence by then Chief Justice Rehnquist in Bush versus Gore, that was joined by then Justice Scalia and Justice Thomas. For our purposes today, so that you really understand the seriousness of this case as a constitutional matter, let me just explain what was behind that concurrence and what they said. The argument for the independent state legislature theory is in the text of the Constitution, namely that in pick which clause you want to talk about, but in the elections clause context, the Constitution empowers the state legislatures to prescribe the time, place, and manner for the holding of federal or congressional elections. From that conferral of power on the state legislatures, the petitioners in Moore versus Harper, for instance, contend that the framers of the Constitution did not intend for those redistricting decisions to be reviewable in state courts by the state Supreme Court under the state constitutions. And analogously was the argument in 2020 with regard to the electors clause, which similarly and in identical operative language confers upon the state legislatures the power to appoint the electors from the state, who, as you know, in turn cast the state's votes for the presidency and the vice presidency of the United States. So what Chief Justice Rehnquist and Justices Scalia and Thomas were concerned with, and this is the issue today in front of the court in Moore versus Harper, is whether there is any limitation through the state constitutions on that legislature's power to redistrict. So the most conservative, textualist, originalist members of the court then and today, they're asking themselves that question. And more fundamentally, they're asking themselves this question. Is there any limitation that's necessary on the state Supreme Courts in their interpretation of their state constitutions necessary in order that we can give effect to the Constitution's conferral of power to the state legislatures? So in sort of political conversation, if you will, the question is, are the Supreme Courts of the states usurping the role of the state legislatures when they interpret their constitutions so as to invalidate, if you will, their state legislatures redistricting decisions? So this is that's the issue, and that's to give full credence to the fundamental constitutional issue in the case. So, for instance, none of us should ever want for another entity of government to usurp the role of another entity's power, as has been granted in the Constitution. By analogy, on the federal context, for instance, this is the stuff of constitutional interpretation every day in the separation of powers. So, it would be, you'd be justified to think of this by analogy to the cases in which the Supreme Court decides as between the Congress and the executive branch, who has the power. That's what the court's doing in Moore versus Harper. The fundamental difference, and what makes this complicated, of course, and makes it a case of federalism, is that, as a general matter, the federal government doesn't have any authority over the state governments, and certainly not the organization of the state governmental bodies. That's what the petitioners are asking the Supreme Court to do in Moore versus Harper, to intercede into the separation of powers, if you will, of the states, so as to limit the state Supreme Court's authority in reviewing the state legislature's redistricting decisions. So that's about as simple as I can explain it in a short form. And then I would just, end my few minutes here with you by underscoring all that Allison said, in particular about the politics of the case, namely that this is not a political case. All of us are of course fully aware of the political implications of the case, but this is a pure matter of constitutional law and constitutional interpretation. And we all want to believe, and I do, that that's the way that the Supreme Court will decide it. One thing I've been saying that would be interest, I think, to all of you on the call today, over the past year, to reporters and media, is this: politicians are, that they make their decisions in legal cases in the moment. They decide what's best for them in the moment, which is fine. But what I've been saying to the politicians is, as to this case and also into reform of the Electoral Count Act, is that you ought to be thinking of it this way. While a certain result today might be good for you, the Republicans, tomorrow this same decision will be bad for you. Now, I'd like to tell you I've had a lot of luck getting people to believe that and understand it and act accordingly, but I haven't. But that's the way all of you in the media and reporters should think of it, because it's just a fact that over time, constitutional decisions on political issues, they will cut one way today and they'll cut the other way tomorrow. Finally, I would just say, as Allison explained, the some of, if not most of, the most prominent conservative thinkers and constitutional scholars have concluded, as Common Cause has, that there's no such thing as an independent state legislature, a theory that would foreclose state judicial review of redistricting decisions. And those people have now filed amicus briefs in support of the respondents in the case. I would just name a few. They're names that even might be known to all of you. But they're many of my friends. They've been in this business, if you will, for 30 or 40 years. They are rock-ribbed conservatives. They are rock-ribbed conservative thinkers and scholars of the Constitution. And they've come to the conclusion that there's no such theory. Names such as Allison mentioned, the Tom Griffith, a former colleague of mine on the United States Courts of Appeals, Peter Keisler, and Allison didn't mention, I don't think, but Larry Thompson, who former Deputy Attorney General of the United States, filed a brief that was authored by a good friend of mine, Richard Bernstein, who was well known to the court and respected by the court. And that amicus brief had, I can't remember, 15 or 20 big conservative political Republican names on it. Next, the Akhil Amar and his brother Vic Amar, who's the Dean of Illinois. Akhil is a longtime distinguished professor at Yale Law School. They filed a brief together with Steve Calabrese, as Allison mentioned. Steve being one of the founders of the Federalist Society. And then finally, I would call your attention to another former colleague of mine on the U.S. Courts of Appeals, Michael McConnell, who is a giant in constitutional law and a conservative giant in constitutional law at that. And he and Professor William Bode at Chicago, who had clerked for Mike McConnell, have now written in the Atlantic that there is no such theory that would foreclose state judicial review. They proposed what they called a middle ground, almost a policy ground, not a legal ground. I'm not going to comment on that today. It doesn't matter. The main point for you is that they have agreed with all of the other people that I've identified that there is no such thing as the independent state legislature as it is being argued for by the petitioners in Moore versus Harper.
Thank you, Judge Liddick. I think that is an excellent roadmap, both to the legal theories that are being proposed or presented, but also the amicus briefs as they've been coming in that are worth paying attention to. We've got a question from Will Duran, and I'm going to direct this to Allison. One of the amicus briefs was from the U.S. government, which also asked to participate in oral arguments to oppose the theory and stand on our side. Can you tell us whether that's likely to be granted, and if so, how big a deal it should be viewed as?
Yes, with 47 amicus briefs, I do feel remiss in not mentioning the amicus brief filed by the Department of Justice. It is a big deal. The Office of the Solicitor General identified federal issues concerning the federal government and its relationship with the states that needed to be defined and protected. I think the brief submitted by the Solicitor General is an incredibly strong one and is one that quite closely tracks our brief. So there's a high degree of alignment, and we were very honored to have the federal government come in on our side. I think the court, obviously, it's always up to the court, but the court generally does like to hear from the Solicitor General, and it's not a guarantee, but it's very likely to be granted, and we welcome it.
Thank you, Allison. I'm just going to remind folks that they can put questions into the Q&A, or if you're more comfortable popping them into the chat, you can do that as well. Judge Liddick, I'm going to ask you the next question. You've shared with us some amicus briefs that we should be focusing on. I'm curious if there were any that you found surprising, either because of the source or the arguments that were being made that are worth noting for the reporters who are on the line.
Yes, Kathy, the first thing that I would say, but for obvious reasons, I will not identify the briefs, is that I think I would say I've been surprised at the lack of persuasiveness of not only the principal briefs, but the amicus briefs in support of the petitioners. That there's no reason for you to know this, but that's to say quite a bit, actually. But it's also revealing of what I consider the surprising lack of merit to this claim, and I would explain that a little further this way. I think all lawyers and constitutional lawyers since 2020, of reading the concurrence by Chief Justice Rehnquist, have believed that this was a serious theory that ought to be considered by the Supreme Court. That's certainly the way I thought of it prior to January 6th. But since January 6th forward until the time that the briefs began to be filed, I was wondering myself as I examined the issue, what exactly, has given rise to this to this theory because I didn't see it. By way of digression, the reason I mentioned January 6th was because, as I said before, this theory was the centerpiece of the election effort to overturn the election. And as you know, I advised Vice President Pence on January 5th that he had no authority but to accept and count the electoral votes as they had been cast by the states. And he didn't have any authority to discount them or refuse to count any of them or otherwise or do otherwise. For purposes of providing that advice to the vice president, I had to come down or to a decision as to the merits of this independent state legislature theory, and obviously concluded that there was nothing to it and advised the vice president accordingly. But so that's when I first began to understand or believe that there was nothing to it. Then we filed our own briefs, and that reaffirmed my own beliefs. But then as I watched the other briefs come in, to Kathy's question, I was fascinated and interested to see what they said and how they defended the theory, and gratified, frankly, at what I saw, namely that I don't believe that it was convincing. It's a convincing case at all. Then on the other side of the line, those who filed amicus briefs on behalf of respondents, I was not. I was, of course, as you can understand, I wasn't particularly interested in or looking for at the briefs of the so-called partisans who would file. I never read their briefs, but I was just captivated by the briefs that were filed by the conservative thinkers and scholars and former Republican officials that I identified. To me, no one knows what the Supreme Court's going to do in any case, let alone this one. But as I would say, and I've said on all, my whole life, all I do is law, and based on the objective law in this case, that I do not believe that the court should do anything but affirm the case in Moore versus Harper, and at the same time reject the most aggressive form of the ISL that's being urged upon the court by petitioners.
We have another question from a reporter, David Lieb. And Allison, since you were one of the two attorneys to argue in Common Cause v. Rucho, along with Emmett Bondurant, I will direct this question to you. Given the court's ruling in Rucho, which suggested and perhaps even upheld the notion that state Supreme Courts can and should review state legislative redistricting decisions, doesn't that give an indication of how the court is likely to rule in this case? And if so, are opponents of the ISL theory, that's our team, overhyping this with a sky is falling potential?
Thanks, Kathy. And it's, of course, a great question, David. Certainly, we thought that the Rucho majority opinion authored by Chief Justice Roberts recognized and understood the scourge that partisan gerrymandering creates, how it polarizes us, how it impedes responsive representation. But that Chief Justice Roberts had a different view of the role of the federal judiciary than we did, which is a position that I certainly can respect. And I do believe that the majority opinion pointed to going to state courts because they did not want us to be condemned to screaming in the void. Now, the challenge becomes the elections clause, as you may have guessed, is not new. None of us know the discussions that happen in the drafting and crafting of an opinion, but it'd be passing strange for the court to have recommended as a solution or relief an avenue that would have violated the elections clause. Notwithstanding that, for some of the reasons, and this was a decision that came down in 2019, but notwithstanding that, obviously 2020 was a moment in time where legal norms seemed to be called into question. And obviously the court granted cert in this case, which means at least 4 of the members voted to hear this case. I certainly hope it's to resolve this issue, to put it to bed and allow this country to move on in a productive and collaborative way. But I think we'd be remiss, particularly after 2020 and the threats to democracy we've seen since then, if we didn't help folks understand what was at stake if this decision goes badly, goes in a way that, as David points out, would seem inconsistent with the Rucho majority opinion. And we believe it's our duty as citizens to not cry that the sky is falling, but to raise serious issues and concerns that affect all of us as Americans.
Fantastic. Thank you, Allison. I'm going to give one more moment for people to pop into the Q&A or chat if they've got a question. I am just pausing for a second to make sure that if anybody is struggling with the Q&A, that they're able to do that.
Kathy, may I say a word while we?
Please do. Please do, Judge Ludick.
To pick up where Allison just left off, and we don't have time to go into this deeply, but I think that all the media and reporters on would want to know of this fact specific to Moore versus Harper, and that is this. It's absolutely critical to the disposition of this case that the North Carolina legislature itself authorized a comprehensive scheme for judicial review of its own redistricting decisions. Mm-hmm. That if nothing else should lead to an affirmance of this case, then it is that fact. And I'll just say in a few words why. And again, we can't take the time here. But again, the court's concerned about the legislature's prescribing the manner for the holding of elections. Here, the legislature itself has said, we want our own decisions to be reviewed by the courts under the North Carolina Constitution. The petitioners are arguing that the legislature cannot delegate that constitutional authority to the state Supreme Courts. That argument will never win in the Supreme Court. So what the North Carolina legislature has done here, I have to believe will require an affirmance of this case, regardless of what the Supreme Court does in its reasoning as to other state legislatures.
All right. Those are positive words, and I'm going to hang on to them, Judge Ludick. We have a question from WRAL in North Carolina, and it does feel that it would be appropriate for me to field that to Allison as our North Carolinian, but Judge Ludick, I'd ask you if you've got any thoughts as well. And that question, sorry, I had it in front of me and then it's just popped away.
You want me to read it, Kathy? I have it.
Here we go. Brian Anderson from WRAL, who, by the way, I'm just going to give kudos to because they are the ones who have gone into the courtroom and provided minute by minute coverage of the oral arguments and the case, the trial court that allows many of us who cannot be in the court to be able to watch it live. So thank you for that. What do you make of the point that the RNC, the NRCC, and the North Carolina GOP state that it does, quote, it does not follow that confining the North Carolina Supreme Court to its judicial role means that the North Carolina General Assembly may exercise its legislative role unrestrained? How do you square, if you confine the North Carolina Supreme Court, that somehow there will still be some kind of check on the legislature?
With all due respect, of course, to my colleagues on the other side of this matter, I've had trouble reconciling some of the arguments made in the petitioner's brief and the amicus briefs. At times, it seems like petitioners don't even know what version of ISL they're advocating for. At core, it seems that some of the proponents of ISL want to limit the review of state legislative action regarding federal elections to federal courts. But again, it really does miss the point. I think what follows from their argument is that state constitutions are irrelevant to state lawmaking. And I think that would offend the founders and the considerations they took into account in crafting our Constitution.
Yep. Judge,
So Kathy,
go for it.
Let me add this to what Allison said. The petitioners are what they're doing and is navigating around the extant Supreme Court precedent, such as Rucho, that appears contradictory to their arguments. And at the same time, they're trying to limit their argument to whatever extent they think is necessary in order to get their fifth vote.
Mm-hmm.
Now, that's what everyone else does every day of the week. That's what we do, in our briefs. The only difference here, not difference, but the most interesting aspect of it is that as Allison said, the petitioners do have Supreme Court precedent that seems to cut against their argument. And so, it's fair game for us to make that point to the court, and we've done so.
Yeah. Very good. I think that the question that we're going to end on is one that comes from North Carolina. Again, Will Duran from Raleigh News and Observer. And so Will asks, how much do we read into the fact that 3 justices would have blocked North Carolina's new maps and let the legislatures go through? Does that mean that they definitely will rule for the North Carolina General Assembly now, or is that going too far?
I never will speculate as to how a Supreme Court justice will rule prior to hearing the case on the merits. It would be disrespectful and certainly beyond the scope of my role here. I'll note what I'm sure most of you know is that when cases go up on emergency stay applications, they're not going up on the full record with fully developed arguments. I believe the court will give us a fair consideration based on the briefing and the record in front of it, and that we've made a compelling case.
I think, Kathy, the way to think about that is by analogy to December 2020 in the presidential election confrontation at the Supreme Court. The fact that the Supreme Court declined to take the case then doesn't necessarily tell anyone that they will not rule fully in favor of ISL. So also in the North Carolina case that we're talking about now, in fact, especially so, the fact that the 3 justices, 3 only, said in the emergency context that they would, grant relief, really doesn't tell us anything at all as to how even those three justices would rule on the merits of the North Carolina case.
We've got 3 minutes left. If you've got some parting words that you'd like to leave with the reporters on the significance of this case and the potential impact, one way or the other, I'll start with Judge Ludig, and then I'd like to give Allison Riggs the last word.
I just, again, would thank all of you for taking the time to try to begin to understand this very important case. It is so complex, and your reporting of it is critically important to the country, that you get it right. There's been some talk today in other broadcasts that I've done about the hyperbole by the parties, and the partisan hyperbole at that. That's irrelevant to decision of this case, and in my view, that's the way it should be reported. Of course, you have to report the political implications and consequences, but the partisanship, including in the briefings, is just noise, nothing more. And if you allow yourselves to be distracted by that noise, then you of course won't be able to cover the story appropriately. This is, as I began, this is a pure question of constitutional law, though it does have profound consequences for politics and for American democracy.
Thank you.
I strongly second Judge Ludig's gratitude to all of you all, part of the media who are parts of the media covering this important case. We know it's nuanced and complicated and heavily historical and may not have the snazziest details to it, but your dedication to understanding the issues is critically important to having an electorate and a citizenry that understands what happens in the courts, what's at stake in the courts, and understands the laws that govern them every day. So thank you for attending a long briefing on a somewhat wonky constitutional legal issue. We're very grateful, and do feel free to follow up with any of us if you have questions as this case continues to develop.
Very good. We've popped a couple of contacts into the chat. If anybody would like to follow up with either Judge Ludig or Allison Riggs, thank you for attending and have a good morning.